Good morning, good afternoon, good evening, good people, and welcome to another episode of Lisa Talks here with Lisa Knox, owner and founder of Knox Law Mediation. You know, we talk about life and love and everything else and laughter and all the things that goes along with law. And today I have a special guest. She is special to the Knox Law family, but she's special and near and dear to my heart as well. So I have Miss Colleen Walpole.
Thank you. Yes, I'm excited to be on the show. Thank you for having me.
Yeah, you're very welcome. Thank you for coming. And so Colleen is going to, let's start off, I guess, by you telling the world or our listeners and so forth. Let's start off by telling them who you are and where you are.
So I am a lawyer and mediator. I focus on family law, collaborative law, and dependency law, and uncontested adoptions. And basically, I focus on respectful resolutions and keeping the child or children at the heart of it. My own background has been working with families and children through, stressful transitions for a long time. I was a teacher of, an underrepresented populations, immigrant children. And as part of my educational administration certificate, I had to take an educational law course, and I got fascinated with the law. So I went to law school part-time, and my journey from there has been in the law. And I have a background in dependency law and family law.
So you have a lot of experience working with children, working with underrepresented populations, working with people in transition and so forth. I'm going to add to that. So I'm going to tell everybody how we met. The funniest thing is that we have so many people that we know in common, but I did not meet you, Colleen, until you joined the board, or until I don't know who was a member first, the board for the Sylvia Thomas Center. Mm-hmm. And so the Sylvia Thomas Center, it serves the community, a specific niche community of families who have adopted through the dependency process, or, even outside of dependency, they can be supportive. And they give resources, opportunities, counseling for the transitional periods, and there's a continuation of transitional periods when you're dealing with adopting through the dependency. And when we say dependency, we mean when the state of Florida steps in to a parenting situation and removes the children, whether it's because, the children are not safe, the parents are unable to take care of the child, if there's instances of abuse or neglect, so forth. And so now the children become, for lack of a better term, wards of the state per se, but then they're able to be adopted by families who are wanting to take care of these children. They're the families that may not be related by blood, but are related by love. And so the Sylvia Thomas Center provides resources to those families. And Colleen is the chair of the board of directors.
Yeah, and I'm very proud and humbled to be a part of that organization. I am an adoptive mother myself. Mm-hmm. So, taking care of families and supporting families that have built their family through adoption is near and dear to my heart. So very important work.
Mm-hmm. So today we're going to have a conversation. If you all, heard, Colleen is an attorney. She's a former teacher, and she's also a mediator, a Florida Supreme Court certified mediator. So we're going to talk about that because you all know mediation is near and dear to my heart. But we'll talk about all the goods, maybe some of the bads, maybe some of the little known secrets of mediation. How about that, Colleen? Are you game for that?
Sounds great.
Okay. All right, then. Stop, though. I do want to talk sort of on the attorney side, because dependency, a lot of times in the field of dependency, people don't realize that, one, they're appointed attorneys, and they have a right to an appointed attorney if they're a parent, right? But two, they can hire private attorneys, right?
Right.
Colleen, have you noticed that quite a few private attorneys and maybe even state attorneys are now walking away from dependency? Because I've sort of noticed that. I realize I am one of very few, a handful of attorneys who still will consider taking a dependency case privately. Is that something that you've noticed as well?
Well, I was an attorney with the guardian ad litem office, and when I was there a while back, very few parents had private attorneys. just didn't have the resources. So, just to be honest, I have not noticed a change, but I agree with you with the fact that there are very few private attorneys representing parents just because of the resources allocation and stuff. So, but it is interesting because in a dependency case, there are more attorneys involved than in a lot of other types of cases, and many people might not realize that. First of all, you have the DCF attorney. Each parent gets an attorney. The guardian ad litem program has an attorney, and then sometimes the children will be assigned an attorney ad litem as well. So it's a dependency case is unusual in that way.
Absolutely. So in that sense, so help me understand and help my team and my community here understand, with dependency, is there also a call to action for mediation? In family law, every case pretty much has to go to mediation. Is there something similar with dependency?
Yes, there are. So there are two main cases, types of cases under dependency. And one is called a typical dependency case, which means the children have been removed, but the parents have a chance to, ameliorate the situation that brought the kids into care. Others are...
I'm going to have to interrupt you there because, listen, I've only had one cup of coffee. Ameliorate? I need you to use a small word. What's the small word?
Rectify the situation, show that they are going to be a safe environment for the children. The other major type is what's called a termination of parental rights case from the get-go, or expedited termination of parental rights, which means whatever happened was so egregious, serious, that it probably, the state does not want to give the children back at all. So to get to your point about the mediation, there is a need for mediators, mostly in the dependency cases. The parents get what's called a case plan. So that means they're getting services provided by the state so that they can provide a safe, nurturing environment for the children. So in the mediation with dependency cases, they talk about what are the services we need to provide this family? What do the parents have to do to, have a safe, nurturing home for their children, and they get a year to complete the case plan. So that's what the mediation usually focuses on. So
are you saying, just for my clarity, are you saying that you can go in a dependency case, you can go in and say, hey, I would like to go to mediation and mediate your case plan or something like that? Is that possible?
Yes. Mm-hmm. So, and that's typically, in a dependency case, that'll kind of happen automatically. The state has certain tasks that they want the parents to complete. The parents may or may not be in agreement. If the parents are in agreement with the task, then there's no need for, mediation. They kind of just, they move on and work on the task. But if there's a disagreement, that's where mediation comes in to kind of, facilitate the discussion between the state and the parents and talk about what really needs to happen in this case for the parents to provide a safe, nurturing environment.
Is there an opportunity in mediation, independency mediation, to maybe mediate and negotiate not having the children removed, or is it only after the children are removed?
Well, typically in a dependency case, the state might have worked with the family with what they call in-home services. Mm-hmm. So if the children are actually removed, then there's probably going to be a time period. It can be a month or 2 months or longer, but the children probably aren't going to be returned immediately. But that can be negotiated as far as the terms and when the children might be gotten back. Typically, one of the tasks on the case plan is, visitation. The parents have to visit with the children, and there's different levels. And so it can be, starts with supervised, and in the mediation, the parents can negotiate who is supervising that. And then the next level is, you can unsupervised in a public place. And then there's just unsupervised in the home. And so there can be some negotiation, discussion around the fact of when are these certain things going to be happening, how does the parent show that they're ready for these different levels of visitation? So I think there's a lot of flexibility with that, as well as, the specific tasks that have to be done.
See, so that's interesting. Question: I don't think, and I'm saying this as an attorney who practices dependency, typically as a private attorney, by the time they hire me, they've already sort of gone through the arraignment. They've sort of gone through, and now it's like work the case plan. There's no negotiations of the case plan. Is there an opportunity to request mediation even after they've gotten onto the case plan or started working their case plan?
Yeah, I think there is. You can, that's something that can be discussed between the state attorney and the parent's attorney, and they can put in a motion for mediation. So, and I would think for the most part, the judges would honor that. I mean, the judges want to facilitate, expedite, the timing of the case. So anything that's going to help move it along, I think would be looked on favorably by the judge in the court.
Do you think that the state, or, as we call it, the department, when we say the department, we're talking about the Department of Children and Families, do you think that, they're notifying these parents and making these parents aware that mediation is an option or is a possible resolution for them? Or does the word need to get out more that, hey, there's an option for, mediation? It doesn't necessarily have to go to court for everything.
Yeah, I think the department attorneys probably think about mediation as far as the case plan. So I think that's on their mind. What might not be on their mind is different things to mediate about and the topics, issues that can come up, because they're just focused on these are the tasks we want because this is the situation in the house, or, so I think, like I said before, the types of visitations or timeframes. So I think mediation could be on their mind, but as far as broadening the issues that are discussed, I think could be helpful and maybe get the news out more about that.
And just so everyone out in our listening world knows, Colleen, this conversation was not just, by happenstance. Colleen is a Florida Supreme Court certified dependency mediator as well, correct?
Mm-hmm. Yes, I am. Mm-hmm. I'm certified in family, dependency, and county.
Okay. All right, then. So that's huge, especially for dependency, because once again, people need to know and understand that they have options. So if they, know of someone, or if they themselves have been involved in a case with the state, either removing the children or putting the children on putting the parents on a case plan or safety plan is sometimes a phrase that's used. These are all things that, you can take forth to mediation and possibly rectify before the courts get further involved. It's been my finding that the longer that the Department of Children and Families and the courts and the attorneys and the ad litems and all of that, the longer that they're involved, the more they're involved and the more insidious. Am I correct? Is that?
Yeah, I agree. And typically, by statute, the parents have a year to complete the case plan. But unfortunately, as you allude to, these dependency cases typically last much longer. It can be 2-3 years. So much longer than, they're expected or that the parties would like.
And are you considered a private dependency mediator?
Yes, I am. I'm not part of a staff of any court, so I'm private. Mm-hmm.
Awesome. Okay. So with your dependency mediations, since you're private, do you have a little bit more flexibility as far as times and ways? Like, do you have to be in person?
No, a lot of mediation is handled by Zoom. So it's very convenient for everybody. And, especially if there's any kind of domestic violence issues, then that, better safety through Zoom. I think the parties don't have to be next to each other and stuff. So. And in mediation, we sometimes use caucusing, which means you're in separate rooms. So again, that provides more safety and can provide just a break or release of tension if need be during the mediation.
Awesome. Mm-hmm. Okay. So now we've talked a little bit about dependency and all, and I do my thing in dependency. Family law is where I live. So dependency is on my street. Family law goes on in the house. So now come on into the house. Get up.
Thanks for inviting me in.
Yes, in the house. All right. So with that being said, you are a Florida Supreme Court certified family law mediator as well, right?
Correct.
Okay.
Correct.
And so now, because I am also a Florida Supreme Court certified family law mediator, so now let's get into the hizzy and tizzy of it, I guess is what my mother used to say, hizzy and tizzy of it. Let's get into the Here's the funny thing before we start. Understand, those who are listening, I am not saying like, oh, Florida Supreme Court certified family law mediator or Florida Supreme Court certified family dependency mediator just because it sounds jazzy. In training, they actually train us to say that you are a Florida Supreme Court certified family law mediator or Florida Supreme Court certified dependency mediator. And that is because people don't realize this, but anybody can, quote unquote, mediate, right? If you agree to let somebody mediate, then they can mediate. However, a Florida Supreme Court certified mediator does so with the training necessary and that qualifies them to go under the rules of the Florida Supreme Court and to have the coverage and protection of being a certified mediator. In addition to that, they satisfy the requirement when it is court ordered, right?
Correct.
So if, there's a disagreement and so forth in a family law situation, you can go to any Joe Schmo. They're not going to, they may not know, as my mother used to say, shit from Shinola about it, but you can go to anybody to make your, to see if you all can come to an agreement. However, if it's court ordered, so if you filed the case already and the court says, okay, you got to go to mediation, you have to use a Florida Supreme Court certified family law mediator in order to satisfy that requirement. So that's my explanation for everyone. But let's talk about that because everybody, as you know, we're both Florida Supreme Court certified family law mediators. And now I'm not going to keep saying that long sentence, right? But we're both family mediators, but there's differences. Right? There's differences in different approaches and so forth. So talk to me a little bit about Colleen and what makes Colleen's approach, work for Colleen.
Well, I think when I do a mediation, there's typical stages. So at the beginning, we have introductions. The mediator makes an opening statement, and then we clarify the issues to be talked about. Why are we here? And then we brainstorm different ways to resolve the issues. Then we evaluate all of those ideas that came about through brainstorming. And then hopefully we write up an agreement. So that all sounds peachy keen and perfect and la la la. But I think what makes me different is I'm able to bring the temperature down in the room so that the parties, even if they come in, all set to stick it to the other person or just, frustrated or worn down, that we can actually work together and increase the chances of a productive conversation, which I think is really important.
And I would say, knowing you, I sort of have the inside track because I know you. And I know that everyone's hearing our voice. I don't think they're seeing our face, but I'm looking at you and I'm smiling as I'm talking about this. And all. You all, in order to know, Colleen's presence, I'm sure you all feel it already, is very peaceful. Like every time I'm around Colleen, it's like, namaste. Like you could easily...
I'm a certified yoga instructor.
You could easily see her doing yoga just as much as you could see everything else. So I think you bring that sort of innate quality to the table, even without saying anything about that. But she's very peaceful in herself and all. But what do you do, or do you do any, Colleen tricks to make things more peaceful when you're doing mediations? Like, I'm going to tell you one of my secrets. It's trademarked. Don't you use it, okay? Here's one of my secrets.
I will, I promise.
When I'm doing a mediation and everybody's hot and angry and all, I do what I call a 1-minute shootout. And that 1 minute, and I don't necessarily tell them like, oh, it's a 1-minute shootout. But if I know they are, really hot under the collar and I have them in the caucus in separate rooms with their attorneys and so forth, I'll go in there and I'll say, listen, it is clear to me that you're mad and the other side is mad too. And those are big feelings and we need to acknowledge those feelings. So I'm going to go ahead and give you 30 seconds to a minute. You go ahead and you say whatever. It's a free for all. You say whatever you need to say and empty your clip. And then we're going to move on. And I just sit and I listen. And sometimes it's funny as hell, and sometimes it's like, ooh, I might have to report you. I remind them I'm a mandatory reporter. But and then we take a deep breath and I say, okay, now let's move on.
Mm-hmm.
So that's my little trademark secret. Now you go ahead. How do you bring it?
Well, I think caucusing the breakout rooms is a really important key tool, because that just, gives them kind of a breather, right? Like you say, and they can vent and then take a breath, come back. Another thing that I like to keep in mind is positions versus interests. And that requires you stepping back. Positions is a want, and it's very specific. If you focus on interests, that's a need, and usually needs can be met by several different ways, and you can get creative. So one example I have of this is a trial that I observed, and the parties were fighting over a $4,000 car. So I was really frustrated. I was like, you guys are paying your attorneys more than this car is worth, So again, to get back to that idea of positions versus interests, the position is the husband wants the car, the wife wants the car. Not a lot of middle ground. But if you go back into the interests, then maybe they need transportation. And transportation can be solved by many ways. Maybe the state can provide bus passes, depending on the situation. Maybe there's a friend or a grandma that can drive them to, medical appointments or something. My point is that if you move from positions to interests, the why do I want this or need this? Typically that leads to more creativity and a better, more productive conversation. So I think that's another important tool to keep in mind.
Absolutely. Now, are there any family cases like you would absolutely say, hell no, I'm not going to mediate? Or are you open to pretty much anything that falls under family law? So, child support, custody arguments, so forth. Or is there anything where you're like, no, I'm not going to be in that situation?
I think if, getting back to the talk about domestic violence, there are some domestic violence cases that you can address the power imbalance, make people safe. But I think there are some cases where domestic violence is involved that you're not going to have a productive conversation because one of the parties doesn't feel empowered to say what they want in this negotiation. So I think in extreme cases of domestic violence, that would probably be one of the few types of cases that I wouldn't take on, just because in mediation, people need to be empowered and have control. That's one of the advantages, is that the parties get to have self-determination. They get to determine the agreement, not the judge, and they're not confined by what a judge says. So, but if there's domestic violence, in certain cases, that doesn't happen. And so the mediation isn't going to be very productive or fruitful.
One of the things you said is that you practice mediation, collaborative, uncontested adoptions, and so forth. So all of that in our legal world, we call that alternative dispute resolution, ADR. At one point in your career, you were a litigator, right? You were going to court every day, right?
Correct. Yeah. When I was with the Guardian program.
So why are you stepping away from litigation, going to court every day, to the world of ADR? Or are you stepping away from litigation and focusing on the world of ADR?
That is the main reason that I started my own firm, so that I can move away from litigation. Litigation costs a lot of money, a lot of time. It can get delayed with all kinds of motions, a lot of money too. I think alternative dispute resolution can save relationships, saves money, saves time, and it allows for more creative solutions. The parties get to determine what works best for their family. As I said before, not the judge. What happens in a mediation is confidential. So, other people, part of the public, aren't going to find out about it, unlike a typical family law case where people can see what's been filed and stuff. So there are several types of alternative dispute resolution. The two main types that I'm involved in are mediation and collaborative law. They are similar, but the two main differences are with mediation, you have a third party neutral, the mediator, sitting with the parties and their attorneys if they're represented. In collaborative family law, you have the parties represented by the attorneys, but we have mental health professionals and financial professionals that are also involved. The similarity is that they don't go to court. The parties and their attorneys and the professionals sit at a table and they work out, draft up the agreement, hopefully. So again, it's not going into court. The parties can come up with whatever agreement makes sense for their family. So that's why I like mediation and collaborative family.
Absolutely. And I will say I am a huge proponent of ADR myself. You know, you all talking to the listeners to the Knox Law family, you all will see that Colleen and I sort of work in the same circles, right? And I know someone out there is going to think, well, why the hell is Lisa putting her on the podcast? Aren't they competitors? And I think it's really interesting because I guess in the broad sense, someone could say we're competitors. I don't see us as competitors. I see us as colleagues because there are thousands and thousands of family law cases, issues, and so forth that come up in just Hillsborough County alone every week. Every week, different ones. And I think that it's a most invaluable resource to be surrounded with people who have the same heart, the same spirit, the same interest in bringing forth resolutions. And we, clearly we do things two different ways because we're two different people, but we're on the same branch. We're in the same tree. And exactly. So that's a good thing. I don't know about you, Colleen, and you don't have to say yes or no, just because you're technically on my podcast, make the right decision, Colleen. So be careful. But do you find that it is useful to be surrounded with people who do the same work as far as, collaborating or so forth, helping each other, learning? I know you've taught me quite a few things that I didn't know about, and hopefully, I haven't been a bump on the log.
No, I've learned a lot from you too.
So, I'm wondering, do you find it sort of enriching to be with?
I absolutely agree. I think the typical lawyer has a scarcity mindset. They're very protective of their own business. But I agree with you that there's enough business to go around. And so it's very helpful. And in fact, I think, it can build more business if you collaborate and network and get to know people, because there's enough business out there, as you said, for everybody. There are also times where there are conflicts and a certain mediator can't take on the case. And so they will need to refer to somebody, So I totally agree with you. I think, to have an abundance mindset instead of scarcity is very important. And I think builds everybody's business.
Absolutely. I definitely agree with that. I'm just thinking, and I'm like, some of my closest colleagues are in the family law world. So, so there's that. Okay. So Colleen, it's almost time to round out and say goodbye to our party people. If you had one thing that you could say to everyone about Colleen's mediation, first off, tell us the name of your firm. We should have started with that.
Sorry, thank you. Wapole Law. Okay. Wapole.
Wapole Law. And what's your website?
Wapolelaw.com.
Okay. WAPOLELAW.com. Okay, so that's the website. If you could have one last time to say something to the audience, what would you tell them? What piece of advice or encouragement or words or whatever, what would you say?
That, they don't have to go about any stressful, scary transitions in their family or their life alone. Reach out. And I think mediation is a great way to work through very stressful transitions in the family. So I would encourage everybody to use mediation and work out so that they feel empowered and they get the best outcome for their family.
All right. Well, then I'm going to go ahead and concur with that. We're going to go ahead and send you all off. In the meantime, good people, thank y'all for listening today. And all, if you like it, comment below, click like, click share, and all. And in the meantime, in between time, be good to yourself and to others. All right. Lisa Knox with Knox Law.
Thank you for having me, Lisa.
You're welcome. Another Lisa Talks is out.